This courtroom drama is about to hit hard, and you won't believe how it ends. Today we're watching the case of Matthew Wodsworth, a man with a staggering 21 felony convictions, and that's just scratching the surface. He's pleading guilty to aggravated assault with a deadly weapon, but as the judge starts peeling back his record, things get jaw-dropping. He claims he's changed. He says the violence only happens when he's off his meds. He's emotional, he's remorseful, he's a father, a grandfather, but is it enough? The prosecution thinks 8 years is too generous, and you'll soon see why. And that's just the first half of this courtroom saga. Stick around because in the second half, a man on probation for domestic violence makes one final plea for freedom. While facing allegations of crack cocaine,
The first page of his, I guess, rolling into this second page of his felony criminal history, most of those are.
when the prosecutor says there's a cap of 8 years, that means both parties agreed before sentencing that the prison term would not exceed that limit. It's part of a plea deal. Normally, aggravated assault with a deadly weapon in Texas can carry up to 20 years. So getting it capped at 8 is a big win, especially with this defendant's record. But listen closely, the judge isn't exactly thrilled. In fact, she hints that
Basically, he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case,
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
now we're entering emotional territory. Wodsworth is reading a heartfelt letter to the judge, a classic courtroom tactic when seeking leniency. He admits he's a drug addict. He recounts being sexually abused. He describes a chaotic life where mental illness and medication compliance have been the only factors separating peace from violence. But here's the real question. Does a tragic past excuse a violent present? Drop your thoughts in the comments.
I was thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin, I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something, and I hope it don't hurt you, but I got bring it up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications.
This is a powerful moment. Wodsworth explains that after a house fire destroyed his belongings, including his medications, he spiraled into psychosis. He believed his roommate was holding his girlfriend hostage, and that's what led to the assault. Mental health is clearly central here, but the stakes are deadly serious. Someone got hurt. The judge has to weigh whether Wodsworth's instability is a risk too big to ignore.
And then I stopped taking them. When I stopped taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Yes, ma'am.
The problem is, you're 51 now, 52?
51. ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take it.
This is the point where the courtroom takes a dark turn. The judge isn't just reading off charges, she's documenting a lifetime of crime. We're talking 21 felony convictions, 19 misdemeanors, another pending felony in Indiana, and 16 additional charges dismissed only through plea agreements. This is more than a record, it's a pattern. The judge
Pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38
We're talking.
felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario,
19 of them was in one.
but
I think
it didn't stop then. You were put back on probation in 2017, so not that long ago, given a probation, it was revoked. So you were given an opportunity.
Here's a red flag. The defense says the weapon wasn't a bat, it was a cane. But the prosecutor fires back, saying Wodsworth is still avoiding responsibility. In cases like this, it's not just about the facts, it's about credibility. Judges look for genuine remorse, not revisionist storytelling. Is this a man trying to explain or trying to excuse?
Maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account to probation where he said the part about the baseball bat is not true. A dresser fell on top of
I saw that.
it. He's still not accepting
I
responsibility.
hit him with the cane.
Hold on,
I'm
don't speak
sorry.
over. I let you talk, so
I'm
don't
so
talk
sorry.
over anyone else,
I'm so
please.
sorry.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence to be sentenced.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement, because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division.
The judge sentences Wodsworth to 8 years in prison, sticking to the plea agreement but making it crystal clear. She didn't have to. Her tone is frustrated. She calls the deal ridiculous given his criminal record, but because it was negotiated in advance, she honors it. That's the power and the constraint of plea bargains in America. Question for you. Should judges be allowed to override plea deals when a
Possess a
defendant...
firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff.
Just when you thought things couldn't get heavier, the next case begins. Devin Keith Burley, already on probation for violating a protective order, is back. And this time, the allegations are explosive. Assault while on probation. Positive drug tests for cocaine and alcohol. Caught in a crack-heavy neighborhood at 3 a.m. And yet, he's asking the court for another chance. You won't believe how this one ends.
The new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is
Right.
no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Burley. So I know that he's entitled to a bond as
Well,
he is on deferred.
Maybe
but-
he is without certain findings, so that's why we're here. So just also for the record, Mr. Burley, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at a other location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what, do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the board is.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be
So I
helpful?
received his case, I became his officer in February of last year.
Okay,
And since then, I have put him in ISF cognitive, I have put him in JCDI. Prior, he's done an MRT. He tells us that he understands that he has a drug problem, but then still continues to go do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he was needing a bond was so he could go work out of county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Can I have?
You may. Go
can
ahead.
I ask her a question? When did you place him on JCDI? Do you have a date of his term? When was he actually placed in? Was it 2019? When he was placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last,
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
his drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions. And we believe outpatient would be the best for him. He had spoken to me briefly as well that he had, some issues he wanted to talk through. He had some family issues he wanted to talk through. So we've got him in front of a counselor, him getting that drug treatment is what he needed. He agreed with us, that's what he needed. So we believe that outpatient program is the best option for him.
Did he go to JCDI?
He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program,
So it was the new offense that dropped him, it wasn't him not going?
as well as the drug use.
And was there another program too, that you said?
He had done ISF, cognitive track.
And what is that?
It is the interesting facility that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else? Mr. Burbank?
Mr. Burley, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer.
This moment's painful. Burley says he had a stroke last year, and yet he's still testing positive for cocaine and alcohol. He says he just wants to go to work. But the judge cuts through the noise. You're doing more than work. You're doing drugs. It's the heartbreaking intersection of addiction, denial, and the limits of compassion in the courtroom. Does he need rehab or a cell? What do you think?
The incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir. It is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I
you
work
would go to.
at, and as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your payments.
Okay. Yes, ma'am.
You had a stroke last year?
Yes, sir.
And you're still testing positive for drugs after having a stroke.
Yes, ma'am.
Okay. All right.
I had family issues, and that's not an excuse, but that's my daughter.
Do you have a place to stay?
Yes, I do.
And where is that?
Two was apartments, Mosaic Apartments is where I
Who
live.
stays with you?
No, I live by myself.
Who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, it's probably Byerly, also my mother, Byerly, and I have an uncle, Christopher Williams.
And how far away do they live?
Well, as far as my mother and my sisters, they live in Houston. As far as a good friend of mine, she lives right there in Port Arthur, in Mount Fraser.
Do you have any kids?
Yes, sir.
And where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, I got two kids here in Beaumont. One that I'm not allowed to see, and then also Tristan, who I just reconnected with Tristan, my 11-year-old.
Mr. Viola, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
Well, for one,
What guarantees?
I would accept that offer of the patch, and I would guarantee, I just want to get back to work. What I do well is go to work and come home.
You do other things because you've done other things.
Yes, I have.
So what's the guarantee that says you're not gonna do those other things when you're doing work and going home?
At this particular time, offer my word, even though the past doesn't.
That's right.
Yes, and that's what I told him, I see this as my last opportunity to keep everything that I have in the house. That's
One of the things is that you tested positive. What date was that, Your Honor? On the,
I don't know, Mr. Burbank, what date is it?
now, I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that date?
yes, I did.
And was there a date also of positive for cocaine? Was there? Yeah, there was. So those allegations are true.
Burley was allegedly found in a car in a known drug zone at 3:20 a.m. with a crack pipe and 4 pieces of crack cocaine. The judge is visibly disturbed. This isn't just a relapse. This is a breach of public safety, and probation had already bent over backwards with rehab programs. Comment below. At what point does the justice system stop offering help and start enforcing consequences?
The allegations, at least for that new offense on May 29th of this year, is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after this is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation, let's work with them, let's work with them, let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest
The judge refuses to set bond. Her message is clear. This isn't about punishment. It's about protecting the community. She lists 5 prior administrative hearings where Burley got chances, got treatment, got support, and still he landed back in front of her. Sometimes the justice system has to say enough is enough. This decision wasn't just about one man. It was about the safety of everyone around him.
and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I mean, I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is. And the
That's fine.
assault, there may be a question
I
on
think
that.
we can get that taken care of if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm going to go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Burley, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let me get this pulled up that way. I think I can do it. So will he waive the formal reading of the motion?
You will, Your Honor.
It's mine, Judge. I'm trying to turn it off.
Mr. Byerly, in 18-28800, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, and that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 18-29063, that's what I need, thanks. Correct. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, third-degree felony, and that was a 10-year deferred probation. Is that also correct? Both of these motions allege that you violated your probation. Count 1 alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates. And is that true or not true? Count 3 alleges, in each case, that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged.
Compliant, yes.
So I'm going to put not true to the way that one is worded. Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count 5 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true? Count 6 alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true? Count 7 alleges that you were at a location other than your residence at approximately 3:19 a.m., May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that if we can get that expedited. All right, we'll see y'all back at sentencing.
What a session. On one hand, a 51-year-old with decades of convictions, begging for a chance to stay on medication. On the other, a man on probation caught in a crack zone at 3 a.m., both men claimed they were ready to change. But talk is cheap in a courtroom. The judge handed down 8 years to one and denied bond to the other. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what happens next.